Good day. We are Great Zimbabwe Herbert Tepo Law School students presenting on module of jurisprudence, and our lecturer is Mr. Maposa. Our group consists of Paidamoyo Ndati Chavunduka, that is myself, Tinotenda Kaseke, Vandros Mugia, Kudzai Majari Ray, Dumisani Zimbabwe. We are going to present on the topic called adjudication. The term adjudication is used to describe the formal giving of a judgment or a decision by a judge in a court of law. For example, an adjudication is made after all the applicable evidence has been reviewed, including the legal arguments put forward by the attorneys. Once all of the information has been collectively weighed, the judge is then empowered to make a decision on the matter at hand. There are three types of adjudication. One, paper-only adjudication, where the parties submit written claims, defenses, counterclaims, and the legal submissions to the adjudicator, along with expert reports and supporting evidence. Having engaged in the usual exchanges of documentation, at an appointed time, the adjudicator goes through all the paperwork, makes a decision, and publishes it. Whilst there is no opportunity at a paper-only adjudication to make oral submissions and to engage in cross-questioning the low cost of such adjudication proceedings is attractive. Second adjudication is called immediately enforceable. This adjudicator is given the authority by the parties to a dispute or by a statute, if applicable, to make a determination which is immediately enforceable, subject to the terms of the award. Typically, the losing party is ordered to pay the winning party a sum of money within a specific period of time. The third adjudication is called non-binding. The decision is non-binding in that, having compelled with the order, the losing party is free to commence arbitration or litigation. Assuming that both parties are completely satisfied with the decision, the dispute is at an end. Even if one of the parties is dissatisfied with the decision or award, the parties are able to continue their business relationship on the basis of the decision, pending arbitration or litigation is done. Thank you. I'm calling for the next student to present.
I'll be taking you to the introductory part of Dawkins' theory of adjudication. The theory of adjudication concerns the proper decision to be rendered in a given case and remains one of the more elusive goals of modern jurisprudence. Dawkins' theory of adjudication is that in all cases, judges weigh and apply competing rights, even in hard cases. One party has a right to win. His theory of adjudication is tied to a theory of what law is. For Dawkins, law embraces moral and political as well as strictly legal rights. Dawkins develops a third theory of law in terms of which the law is neither merely the rights nor duties created by legislation, custom, and precedents, nor is law merely the edicts of natural law or morality. Rather, law is the body of rights given expression to in legislation, custom, and precedents, plus the political and moral rights that is implied by the political theory that best explains and justifies the existing legislation, custom, and precedents. The task of a superhuman judge Hercules is to construct a political and moral theory that best explains and justifies the existing legal materials. That ruling theory being the best guide to the right, Hercules must apply to reach the correct decision in a hard case. Dawkins has produced a sophisticated version of the open system in theory of adjudication. The next presenter, Tinotenda Kaseke, will be taking you through the doctrine of precedence.
Hello guys, so I'm going to be continuing from where Kuzi left. So the main theorist on the issue of adjudication in this matter is Ronald Dawkins, right? Ronald Dawkins focuses more on adjudication on hard cases, which are the gray areas of the law, or areas which are left out, which can be also called penumbras or lacunas. He discusses theories central on the law and its importance of rights. According to Ronald Dawkins, the purpose of the law is to guide and constrain the power of the government, and the law should further protect individual rights in the society and ensure equal respect and treatment. Ronald Dawkins speaks of conventionalism, the right thesis, and also pragmatism. My fellow counsel is going to explain more on these theories. We are also going to include theorists such as Joseph Raz and also
following up from what Tino has been saying and from the previous presentation. So my name is Vandros Mugia. So basically from what Tino has been saying, I'll be using this template for the quotations and further notes. So please be here with me. Okay. So I think Tino has already reflected on the lacunas or the hard cases of the law, which in fact is what Ronald Dawkins actually expresses and tries to explain a lot more. So there's a quotation here by Ronald Dawkins which says, "The purpose of law is to guide and constrain the powers of the government, and the law should further protect individual rights in the society and ensure equal respect and equal treatment." So basically what we are trying to say is that Ronald Dawkins was saying that in all forms of adjudication, the goal is to protect, firstly, individual rights, secondly, to protect equal respect and equal treatment in the society as a whole. Which means that no matter what was going on, or no matter which case it is, these three essentials have to be satisfied by a judge or any form of adjudication. Moving forward, I think from the Constitution itself, it speaks about constraint of power of the government, which from my perspective was basically saying, was basically revealing the doctrine of separation of powers, trying to limit the power of the government and trying to review the three arms of the government. Moving forward, there is also a quotation here which says, "However, judges are guided by standards, policy, goals, and visions. Some can dare say ambition when the law does not specify." So from what Tino was saying, he was talking about penumbras and lacunas of the law. In these situations, this is where we see that the judges are guided by standards and policy, not per se the law itself, because the law will be gray. The law wants to say something which is explicit. So the judges will now be held by standards, policy, and the goals of the nation in general. So now we move forward. We move forward to what Tino had already introduced in terms of conventionalism and pragmatism. Firstly, when we say conventionalism, what we mean is this is the interpretation which proceeds with reference only to statutes and precedents. Therefore, judges would be centered. What we are saying when we're talking about conventionalism is basically that the judges are centered on interpreting the law. They're centered on wanting to know exactly what the law says and how they should actually administer it on the specific cases. The second theory would be pragmatism. Pragmatism allows judges to interpret the law based on what is best for the community as a whole, and the pragmatism approach is criticized on the basis that judges will be formulating new law. So I think the pragmatic part would be that the judges will be trying to interpret the law based on what is best for the community. We're saying that in terms of any case that arrives, the judges have to interpret it and they have to actually reason with themselves to find the best narrative or the best solution which is best for the community as a whole. But then the criticism now comes in to say that the judges will now be creating new laws, since what might be best for the society might not be indoctrinated into the law. Okay, so we move forward to another part where Ronald Dawkins says he brings out the task of a superhuman judge, Hercules he calls him, is to construct a political and moral theory that is best explains and justifies the existing legal material, that ruling theory being the best guide to the rights Hercules must apply to reach the correct decision in a hard case. We're basically saying that Hercules, this superhuman judge, won't be influenced by anything, won't be influenced by outside factors, won't be influenced by anything, but then you will be trying to do best, trying to do what is best for the society in a hard case. So, an example that we have is the Riggs versus Palmer case, which can be said, which was basically, can a murderer be the heir to the murdered person? You understand? The task here is to evaluate the current law and the morals of the society vis-a-vis the rights, just, and the cases as a legal concept. And obviously from your own ruling, you would understand that a murdered person we cannot give the heir to a murdered person to the murderer himself. Joseph Ra's opinion is that judges are human beings with feelings, opinions, and beliefs. Hence, they are influenced by background, current social weather, and the general surroundings in making decisions. Therefore, under the influence of all the above, a simple adherence or a literal interpretation of the law would not suffice to determine the case of Riggs versus Palmer, because the decision would amount to an absurdity, as we have already adhered. Hence, the judge decided that a murderer cannot be an heir to the murdered person, because in principle, one cannot be allowed to benefit from his own crime. So now we move on to what, in terms of precedence, right? So in terms of precedence, Ronald Dawkins said, precedence gives two examples of forces. The first one is enactment force, the second one is gravitational force. The first one would be enactment force, which in terms basically means its effect on future cases covered by exact words. It means that if a case is done today, it has a direct effect on a case that follows tomorrow. In terms of gravitational force, it means that its influence on later cases that fall outside the language of its opinion. This is justified by the fairness of treating like cases. A case may not be exactly the same, but then if it has the same concepts and the same legal questions, they can be decided in the same manner. It won't be binding as such, but then it will be influential. So, moving on to what Tino was saying about H.L. Hart in terms of gravitational force and enactment force, we are saying that Hart speaks on rules of adjudication, primary and secondary rules. Now, as we move forward, in line with precedent, the primary rules would apply to the facts of the case. The secondary rules would now bring in the concept of precedent itself. And adjudication in an effort to uniformly and orderly develop the law. So you're basically saying that adjudication will now be the third law, which now builds up both the primary rules and the secondary rules. So now, as we now move towards my conclusion, we now have a concept which is basically a constitutional avoidance. Constitutional avoidance comes in with the preference of deciding a case on any other basis other than the one which a constitutional issue is being resolved. In S versus Mulungu, it actually says, I would lay it down as a general principle that where it is possible to decide any case, criminal or civil, without reaching a constitutional issue, that is the course which the court should take. This is basically what constitutional avoidance is. So constitutional avoidance is linked to justiciability, which in principle contains three principles, which are standing, ripeness, and mootness. Both these three principles will be explained by Dumisani Zegwa in terms of the case law that he will be providing for you later on in our presentation. So firstly, we have standing. Standing just basically refers to local standard or local standard, which refers to the relationship that the litigant in a case has to the relief that they seek. We can actually get this on Section 85, subsection 1 of the Constitution of Zimbabwe, 2013. When we move on to mootness, we're talking about it seeks to prevent a court from deciding a case when it is too late, or this may relate to when there is no longer existing issue for the parties to be decided upon. The third part is ripeness. It stems from the principle of avoidance. The main goal is to prevent the courts through avoidance of premature adjudication or from entangling themselves in abstract disagreements. Now, in a conclusion, just to wrap up on ripeness and adjudication in general, therefore, ripeness awards the leaving of a matter too early, and mootness regards to the justiciable of hearing a matter too late. I think that is self-explanatory. So now I will leave Dumisani Zimbabwe to reflect on the Zimbabwean jurisprudence pertaining to adjudication to the case law that we have in Zimbabwe, and then you'll be linking to the adjudication and the Zimbabwean cases that we have. And with that, I am to say thank you.
As I alluded before, my name is Dumisani Zimbabwe, and I'll be dealing with the contemporary cases, particularly, like alluded before by my colleague, that we have conventionalism as a theory, philosophical theory of adjudication. So, particularly in this, we are saying that judges are confined only to the law, particularly with statutory law, common law, and precedents. So, essentially what it means, the judges, when interpreting or when they are making decisions or when they are making rulings, they should always stick to that common law, to that statute or to precedents. So I will try to start by the case of Commercial Farmers Union versus Minister of Lands. So the brief background facts to this matter is that it was during the Land Reform Program where Parliament enacted the Land Acquisition Act, which act empowered the Minister of Lands and Agriculture to actually compulsory acquire land from the owner without compensation. So, Commercial Farmers Union, it was a union or an association which represented farmers. So it actually challenged the decision of the Minister of Lands. And then the decision of the court is quite interesting in the sense that the judge actually said the law was on the side of the respondent, while his justice was on the side of the applicants. In the sense that it simply meant that the decision or the judgment by the court was that it was lawful for the Minister of Land to actually acquire the land, because the judges were constrained, and they were only restricted to apply the Governing Act, which was the Land Acquisition Act. However, it was unjust on the part of the farmers who had lost their land. But the judge had to enforce the act, although predominantly and inherently it was unjust. Moving on forward, we have the Zambezi gas case, in which the Minister of Finance actually passed a statutory instrument, which was actually empowered by the Finance, the Exchange Rate Act, which empowered him to actually pass the statutory instrument, which statutory instrument had an effect to say that the US dollar and the Zimbabwean dollar were at par. Meaning to say all those people who had banked their money in US we are now receiving that money in local currency. So it actually sparked public outrage, resulting to litigation. And the decision of the court was that the statutory instrument passed by minister was to stand, and the court actually enforced that decision. And this decision actually caused a lot of noise and dust among the public, where they actually lost their money, or supposedly or allegedly have lost their property. But however, the judge was restricted to enforce and apply the law alone. So moving on forward, we shall also look at Magaya versus Magaya. Magaya versus Magaya, we see that the court actually drifted from the principle of stay basis, which is to stand by previous decisions, which is actually cemented by conventionalism, because conventionalism is a theory which asserts that judges they only stick to what has been previously decided. So in Magaya versus Magaya, the Supreme Court of Zimbabwe actually then decided to change or to drift from their previous judgment, which actually said in Katekwe versus Mchabaywa, where the court reasoned that a female who has reached the age of 18, which is the age of majority, could actually sue for seduction damages. And the argument raised there was that under customary law, a female is a perpetual minor. But the court then said, due to the Legal Age Majority Act, it was now accepted that a female major can actually sue on their own behalf, unlike previously where the father or the guardian of the female would actually sue. And then it was that. And then after that, the Magaya versus Magaya, the court actually said, no, the Legal Age Majority Act did not prescribe new rights. So we see that the court now had drifted from conventionalism. It was using a pragmatic approach, in the sense that they were saying, no, our previous decision was wrong, we have a new decision, although state basis would require them to stick to that precedent set by the Katekwe versus Mchabaywa. But the court in Magaya versus Magaya actually drifted from that. So we are now moving on to pragmatics, and we see that sometimes judges actually, particularly where in cases where we have penam or lacuna or a gap which needs filling, and as we all know that it takes time for the parliament to enact new legislation, there are procedures, but the problem is still there and it needs to be addressed. So pragmatism allows judges to be creative, to think out of the box, to think out of that restriction that I should always apply common law, I should always apply statutory law, I should always apply precedent set. But our society is always evolving, and societal changes actually affect judges in their decision making, affect judges in adjudication, although they are mainly affected by the law, the common law, by statute, by precedents. But societal views, societal changes, justice also are affected. So we have, in the case of age versus age, it's a common law perspective from industrial law. It says that a husband cannot rape their wife. But that notion or that position, common law position, was maybe developed some years ago, maybe 200, 300 years ago. And our society has changed. So we have a judge in age versus age who actually sees that there is a gap, there is a lacuna in the law, and it is upon me to act and develop the law. And that judge is what we call a judicial activist. He actually created the crime of marital rape. Now it's actually codified in our Criminal Law and Codification Act, but it was due to the effect of age versus age. Like alluded before by my colleague, I shall also delve in more to what we call constitutional avoidance. So basically, like what has been alluded before, the constitution does not exist in a vacuum. It has to coexist with existing legislation. So in the case of Chawira versus Minister of Justice, The brief facts behind these cases is that a set of prisoners who had been punished to the death sentence or the capital punishment, some had maybe 7 years still on death penalty, they had not been executed. So they actually approached the Constitutional Court of Zimbabwe saying that, seeking that, actually alleging that this was unconstitutional in the sense that it violated the right to dignity, right not to be treated in an inhuman way, right not to be tortured. And then the court actually reasoned that no, that matter lacked ripeness, that it was too early for them to approach the court. And then there were existing legislation, acts of parliament, which dealt with those issues they had raised, particularly the Administration of Justice Act, which actually governs how prisoners are kept and how their sentences are executed. So the court actually said, no, this matter has not reached the level that it is required. Perhaps maybe if they had approached the Minister of Justice and he had denied to hear their views, or reached the High Court and seeking a declaration in relation to the Administration of Justice Act, they haven't done that, and also reached the Supreme Court. Perhaps at that stage, the Constitutional Court might have actually lent an ear to hear their matter, but however, it was dismissed on those grounds. And also on mootness, mootness is alluded, has been said by my colleague, it relates to that a court cannot decide in a matter when it's too late. We have this Zimbabwe case where we have a student actually approaching the court saying that the manner in which an examination was carried out was unfair, and things like the registration fee were too high. But when that student actually approached the court, the examination had been already written. So it was too late for the court to preside on such a matter. It's pointless for the court to pronounce a judgment on that, because particularly things to do with jurisdiction, the jurisdiction actually centers or hinges on the fact, is the court able to enforce its judgment. So in those cases, the court cannot enforce its judgment on a matter which is too late. So these are my submissions with this.